Hi, my name is Rob Friedman, Managing Editor of Foreign Policy Digest, and we're excited to bring you another installment in our video interview series. Today we're going to talk with Justin Florence, who is a fellow at the Georgetown Center on National Security and the Law, and a civilian attorney for Salim Ahmed Hamdan, who was recently convicted by the military commissions at Guantanamo Bay, Cuba. In the first trial by a U.S. military commission in more than 60 years, a jury of 6 military officers on Wednesday reached a split verdict in the case of Salim Ahmed Hamdan. The commission acquitted Mr. Hamdan on a conspiracy charge, but convicted him of a separate charge of providing material support for terrorism. And yesterday, in a separate sentencing phase of the trial, the military jury ignored a Pentagon prosecutor's plea for a 30-year-plus term and sentenced Mr. Hamdan to 66 months in prison. With credit served for time given by the judge, that means Mr. Hamdan might be eligible for release as soon as January. We are here with Justin Florence, a fellow at Georgetown Center on National Security and the Law, and a civilian attorney for Mr. Hamdan, who will hopefully help us understand the implications of the recent decision.
Thanks, Rob. I just wanted to mention also at the beginning, although I am one of Mr. Hamdan's civilian attorneys, that I'm speaking just in my own capacity and not on behalf of either Mr. Hamdan or the full legal team, but it's good to be here. Thanks.
Great. We're happy to have you. If you could just start with sort of the basics. Under what authority was Mr. Hamdan prosecuted in this case?
The authority comes from the Military Commissions Act, which Congress passed in the fall of 2006, leading up to the midterm elections then. And in the Military Commissions Act, Congress created these commissions to allow for the prosecution of certain people who are being detained at Guantanamo.
The Military Commissions Act that you just mentioned, that was a direct response to the last time Mr. Hamdan's name was in the headlines. Isn't that correct?
Yeah, it was. Again in 2006, although earlier in the spring of 2006, the Supreme Court issued a decision in a case in which Mr. Hamdan challenged Secretary Rumsfeld. And what that case was about was an earlier version of the military commissions, which had been set up just by a presidential order without any congressional authorization. And what the Supreme Court held there, among other things, was that the president lacked the authority to establish these commissions without Congress, and that the original version of the military commissions were in conflict with at least one aspect of the Geneva Conventions. So the Military Commissions Act was Congress's effort to respond to that decision and to create a new system, which in theory had a little bit more legal foundation to it to move ahead with the prosecutions.
I see, that's interesting. So what's going to happen next now for Mr. Hamdan? He has an option both of appealing through the military review process and then also through the civilian courts?
Yeah, there are a lot of options, and what's interesting here is that this is the first conviction and the first full trial in one of these military commissions, so nobody's quite sure how it's all going to play out. One of the options is that the Military Commissions Act itself provides for an appeal both to a second military court and then on to the civilian courts here in Washington. So that's a sort of statutory access to appeal that Mr. Hamdan has available. There's also still the question of what sort of habeas rights he has to challenge both the trial that just happened and his ongoing detention. So there are a lot of decisions that he and his lawyers will be grappling with over the coming days and weeks.
Interesting. And just in your view, what do you see as the most critical implications of this first of its kind tribunal?
I think there are a couple things we can learn from it. One is that the U.S. military has a lot of very thoughtful and concerned and honest people serving it with a lot of integrity, and I think we can have some real confidence in the men and women who make up our military. The judge in this case, who did an admirable job, is a captain in the Navy. The 6-member panel that decided on both his guilt on certain charges and on the sentence were all senior officers in the military, and I think everybody involved can have a lot of confidence that these men did a very good job here. The other lesson we can take from this is that there's a lot of confusion and concern with the system still. That even though in this one case this group of military officers seem to have done a pretty good job. There's huge questions that still remain about the viability of the commission system. And in particular, sort of the most fundamental question here is, just a couple of months ago in the Boumediene decision, the Supreme Court held very clearly that at least some parts of the Constitution apply to Guantanamo Bay. Now, the military commissions process, Congress designed under the assumption that there was no constitution in Guantanamo. So here we have a sort of constitution-free trial system that's taking place in an area where the Supreme Court has just very clearly and explicitly held that the Constitution does apply. So there are all sorts of questions about the rules and procedures and evidence and substantive offenses that were used in the military commission, and whether they can have any viability when they're looked at in a constitutional framework.
Now, if we could just take one step back so our listeners can understand the distinction here. If you could just briefly explain the difference between pursuing your habeas rights and pursuing or challenging your detention via the tribunals.
Yeah, there is a lot of confusion around this issue, so just to sort of back up is a good idea and fill in a little of the details. So there are over 200 detainees currently at Guantanamo, and I think about 80 of them, Mr. Hamdan and maybe 79 others, the government has said that it wishes to prosecute for war crimes in military commissions of this kind. Mr. Hamdan is the first. Other detainees who are at Guantanamo, the government has said that it has no intention of actually prosecuting for any specific offenses. It's just going to hold them, as long as it wishes, as enemy combatants in the ongoing war on terror or whatever other conflicts. What the Supreme Court's Boumediene decision from June involved directly was habeas petitions filed by people who have not had charges leveled against them saying that their detentions as enemy combatants are unlawful. And the Supreme Court said that yes, these people who are detained at Guantanamo do have a right to have federal courts hear their habeas petitions and decide whether the president has the legal authority to hold them. The question of what sort of federal judicial review people who have been tried or are being tried by military commissions have available to them is still up in the air a little bit. The government, at an earlier stage of Mr. Hamdan's case, said that it didn't see any reason why people who were being charged before military commissions wouldn't have the same habeas rights in federal courts as other detainees. But I know this was something that you wanted to talk about, so I can just sort of transition over to it. In our own case, before the military commission began, we asked a federal judge here in Washington to halt the trial of Mr. Hamdan in order to take into consideration these habeas issues and what habeas rights Mr. Hamdan had. And he declined to do that for other reasons, but there's still big questions that I think will come up maybe in Mr. Hamdan's case and in others about the interplay between military commissions and habeas review.
So if I understand the Boumediene decision, it indicates that there are some constitutional rights that are on the table. Do you envision those being developed sort of in piecemeal fashion and through other habeas petitions that are filed?
Yeah, there's a couple ways this could go. One is here in Washington in the federal district court, all of the Guantanamo detainees are having just a couple of judges here consider their habeas petitions, and in that process both the government and the detainees have filed briefs making arguments about to what extent the Constitution applies. Is it just this one clause, the suspension clause, which refers to habeas? Is it other separation of powers, structural type limits that the Constitution places on what sorts of actions the government takes? Is it certain fundamental rights like due process? And so that's something that judges here on the federal court are figuring out. There's also in the military commission itself, Mr. Hamdan in the pretrial stage made certain claims about what constitutional rights applied, and on appeal he will raise some of those arguments again likely. So there's sort of at least two locations where the judiciary is struggling with this issue. And then another whole dimension to just complicate things even more is that the administration and the Attorney General have asked Congress to get involved in this again, and so Congress may consider doing some more legislation to sort of delineate a little bit more what rights it sees the detainees as having.
Well, thank you. That's all the time that we have for now. Once again, this was Justin Florence, who's a fellow at the Center on National Security and the Law at Georgetown University and a civilian attorney at Mr. Hamdan. Thank you very much for joining us.
Thank you, Rob. I appreciate it.